Hey, everybody. Welcome. Nice to see everybody today. Lots of familiar names and faces. We will give it a few minutes and get started shortly. Now, Rebecca, I'm not able to open that Q&A panel again.
How bizarre.
We solved it last time.
I did too.
Let's go with the system we used from before, and then we'll look into troubleshooting this more. But you just let me know the questions in the chat window, and I'll pay attention to that, to whatever people share.
I absolutely will. And after we get through intro, I will check the settings.
Thank you. Okay. Wonderful. I'm just gonna jot down one thing, and then we're about to get started. Okay. Well, there we go. Oh, it restarted. That's okay. Here we go. Let's get started. We are here to talk about the American dream and O-1A visas, EB-1A green cards, and other immigration options of note for professionals. Rebecca, can you share all of our lawyer disclaimers and fine print, please?
Of course. Good afternoon, everyone. Thank you for joining us for our presentation today. I have a few housekeeping items just before we get started. This webinar is being recorded, and the recording link will be available to you after the webinar. The presentation is an educational service by Alorn Immigration Law, and the information discussed should not be construed as legal advice for any specific action and is an overview only. Please be sure to consult a knowledgeable professional for assistance with your particular issue. Lastly, please submit any questions you may have by using Zoom's Q&A function below, and do so anonymously. These questions are shared publicly, so please do not share any sensitive or personal information. It's now my pleasure to introduce you to our founder and CEO, Sophie Alcorn.
Thank you so much, Rebecca. Appreciate it. Hey, everybody. My name is Sophie Alcorn, and welcome to my webinar today. I will be happy to answer all your questions. As Rebecca mentioned, put them in the Q&A panel. I'm having technical difficulties seeing that panel right now, so Rebecca's going to share the questions with me, so I will get them. And let's see, what else did I want to say? I have a lot of material. I can talk forever about this stuff, but I would much rather make this presentation dynamic, useful, valuable, and interesting to you in answering your questions. So feel free to ask questions throughout. For those of you who do not yet know me, it's a pleasure to meet you. I'm the founder of Alorn Immigration Law and the host of the Sophie Alcorn podcast. I meditate, I'm a mom, and I believe that the world should be a place where every person who is born on this planet has the opportunity to self-actualize, become their best selves, be in that Maslow's hierarchy of needs at the pinnacle, find their flow state, find their bliss. And when everybody's doing that and we're all following our hearts, we'll all be acting in symphony to create a really amazing planet that's happy and healthy and abundant and sustainable for all. So that would be my hope for the world. And I'm very grateful for the opportunity to play a small part in that by helping to remove some of the obstacles that can be in the way when it comes to people pursuing their dreams, such as U.S. immigration. You're always welcome to reach out to me. And I'm looking forward to chatting with you guys today and sharing what I know. Our team is growing, and I'm very thrilled to announce that we have two new attorneys who just joined our law firm, Vanessa Oliver and Kellen Powell. So if you've been to some of my webinars in the past, and if you're on our newsletter, you'll see that down the road, hopefully they'll be joining me in future webinars. So very excited to have them both on the team. founded Alcorn Immigration Law 9 years ago out of my kitchen. We've grown. I just did the math. We've helped over 4,000 people get visas and green cards to the United States in the last 9 years. And now with our growth, we're taking the law firm to the next stage to be able to scale with our startup clients, as well as continuing our commitment to professionals and early stage founders in the United States. I'm based in Palo Alto normally. We're remote. Everybody's either usually everybody in our team has some very personal connection to immigration. Often it's being the child of an immigrant, like I am. My mom's from Germany. My dad was an immigration lawyer. Or some folks on our team are immigrants themselves, or they're married to immigrants, but everybody's really passionate about helping our clients and providing the best possible service to make the U.S. immigration, visa, and green card process as smooth as possible. So as we dive into the content that I would like to share today, just some initial notes to set the stage on how this all works. So my goal in really highlighting extraordinary ability pathways today will be primarily focusing on O-1 visas and EB-1A green cards, but I really can't talk about those in a vacuum because it's the overall context that will help you figure out which strategies might be most helpful to you to achieve your dreams and unlock you at each stage of your journey. It's usually a multi-step process, and we have to be able to mix and match pieces and fit together components in different ways to basically get you from where you are now to where you want to be. So having the context really helps, but I'll be diving in a lot to what my clients want to know the most, which is basically people ask me 4 questions. How qualified am I? Will you accept my case? How much does it cost? And how long will it take? So I hope to shed some light on those common answers and the context for all of them today, and also answer any of your questions along the way. So excited to have you here. Okay, so just in general, like, why does this all matter to people? Well, it's usually one of 4 reasons. People need stability and security for their family. They need to be able to travel the world and move around freely and know that they can come home here. They want to have the freedom to advance their career, and they want to have the freedom to create new things. And so, what's driving somebody who's married and 35 and has a mortgage in the Bay Area, right, who's on H-1B and their spouse is on an H-4 EAD and they have a 2019 priority date and they want to upgrade to EB-1A, they're going to be at a different life stage than, maybe somebody who's in their first year of their master's and they haven't been married and they just got to the US a few months ago and they want to be a startup founder as soon as they graduate or even now. We help a wide variety of people, and we can do that because it's a lot of the same tools and techniques, but it's how we put them together to create that individualized approach and strategy for each person. So I hear a lot of reasons why people need an extraordinary ability pathway. One today was, well, my 6 years on H-1B ran out and my employer had layoffs and I don't have a priority date and I'm stuck in India. And if I could only get a priority date through an approved I-140 self-petition, I could come back, start getting 3-year H-1B extensions and look for work again. That's one example. Other people might not be able to get an H-4 EAD for their spouse. And by having that first priority date, they might be able to help their spouse be able to get a job here. Other people are just facing that really long wait time to getting a green card because they don't have anybody who sponsored them yet. And they're trying to figure out what steps they could take today to potentially reduce their wait from what could be decades if you were born in India, maybe down to just a handful of years if you can play your cards right and execute the strategy correctly. Other folks have had visa processing delays and maybe got stuck in their home country when they were on a trip to, for work or to see their family, spend time with relatives. Maybe there were health issues that came up, right? But then they've gotten stuck abroad if they couldn't get their visa appointment in time. That can be very challenging to navigate. Um, and, even for people who feel pretty stable about their travel ability, just having the freedom to advocate for themselves professionally and not just to have to say yes to everything that's requested of them in the workplace, and have that freedom to be able to say no, to choose the projects, to do the thing that actually is interesting or, financially valuable to them rather than what the visa is supposed to be for. That's a huge freedom, a huge economic freedom. And then we work with a ton of startup founders, and they are passionate about figuring out the way the world should work and solving their own problem and building something that people want, and all of those buzzwords from YC and the startup founder entrepreneurship community. There's so much thought leadership on those topics, but basically people want to be entrepreneurs, they want to be startup founders, they want to have the freedom to fail. It's one of the big benefits of being in the United States. We're a culture that respects people trying things. And if they fail, standing up, brushing themselves off, and trying again, we actually reward that quite heavily in our society. And that's a huge advantage culturally to being in the United States compared to the economic and cultural environments in other countries. So lots of reasons for why these extraordinary ability pathways are valuable. So today we're going to talk about all sorts of things. We're going to look beyond H-1Bs, an OPT to figure out a priority date, to figure out how to get an O-1, to figure out how to upgrade maybe from an EB2 NIW or EB2 based on perm to an EB1A. So primarily we'll be talking about O-1A and EB1A and extraordinary ability and what it takes and what the categories are and who qualifies and sample profiles. But I'm going to nest it in the context of business immigration law at large. So the main thing to start out with is a pretty, high level understanding of how the U.S. immigration system is structured. Essentially, there's three buckets. There's ways to be here temporarily, there's ways to live here permanently, and then there's a pathway to citizenship through the naturalization process. So you don't have to do all of these. You have to have a visa before. Excuse me, you don't have to have a visa at all, ever. You could simply jump ahead and get a green card, but you probably don't want to wait. And that at minimum might take 1 to 2 years for somebody not born in India or China who is EB1A extraordinary ability qualified. And it's faster if you're in the States rather than abroad. But there's no requirement to have a visa before having a green card. If you want citizenship, you definitely have to have a green card, usually for 5 years. But if you've been married to a U.S. citizen and living with a U.S. citizen for 3 years, then you can apply for citizenship in 3 years instead of 5 years. So the O-1 is a visa. The EB-1A is a flavor of green card pathway, but ultimately the labels matter more for visas and less for green cards in terms of the outcomes. So with a visa, the visa category you get determines how long you can stay, if you can work, how many jobs you can have, and like how frequently you have to renew it, and your ease of travel, and if you can get a green card in parallel and travel. So the visa determines a lot of things about your life. The green card is really just like a mountain, and there's lots of pathways up the mountain, but when you climb to the peak, it's the same peak. So like one side of the mountain would be marriage and family-based green cards. Another would be, did you get your green card through a lottery if you're from a country with low levels of immigration? But the side we're going to be primarily talking about with EB1 is the employment-based set of green card pathways. And at the end of the day, they're all ways to get permanent residence. you have a green card at the end of the day. It's a lifetime status. The card is good in 10-year increments. Every permanent resident can do the same things as every other permanent resident. So it's really more of just a route to getting there rather than like a flavor of thing that you end up with. So those are some important considerations as we move forward. So one of the reasons why this whole discussion is particularly important is because for the types of people that I tend to help in my law firm and our team in our practice, we primarily help technology professionals, everyone from startup founders to founding engineers at early stage technology startups to teams at rapidly scaling startups, and also for people in the corporate landscape, professionals that for whatever reason need to take their immigration into their own hands and get that stability for themselves and their lives. I have a lot of people in two different camps. Some people are like, oh my God, I have to start my company right now. I don't care what visa things I have to go through to make it happen. Make it happen for me. And then I have another distinct group of individuals who are experts in their field. And they're like, I can't deal with a startup until I have the stability of a green card. So I don't even want to think about it. I just need to get the green card. Then I'll give myself permission to think creatively about what I might want in my future. So it doesn't matter, wherever you are in that spectrum is fine. But it's important going into this discussion to have an understanding of what is work, which matters in immigration law because immigration laws restrict your ability to work in the United States. And so if you want to have work outside of your visa or additional work authorized by your visa, it helps to know what you can and can't do while you're on one of these paths. So there are a lot of things that are not work, and that's great because you can do them even when you're on an F1 visa with no CPT or OPT, and you can do them on an H1B even if you don't even if you're only authorized to work at one company, or if you're on an O-1, even if you're authorized to only work at one company. And US immigration law defines work as, this is my definition based on a very old case, because immigration is also based on case law in addition to regulation. So the basic concept, as I interpret it, and most immigration lawyers interpret it, is you can't work in the US. Okay, well, what is work? Work is doing activities with the intention to make money from it now or in the future. And typically, I mean, the most obvious example would be getting a job at a company and getting a paycheck for performing labor. But there's a lot of things that people might want to do that are not that. So we have to look at that conceptual test to figure out, could this be considered work? Would it violate your status? So things that would not violate one of those statuses that I mentioned can be internships, such as a practicum, or observing and documenting what people do in different roles, shadowing them, interviewing them. Some things that founders need to take initiative on could simply be the role of a passive business owner and not somebody performing services for hope of future remuneration. So that could be things like brainstorming on a business plan, conducting user interviews to research problems in a specific industry, or even establishing a corporation and registering a company. You can own a company, you just can't work there. So usually my clients hold off on forming any companies until they have a very concrete idea of what they're building and a very concrete plan of how their immigration is going to allow them to work legally very soon after the company formation. And volunteering with no pay and no like, hey, in 4 months, we're going to give you a bunch of money for this volunteer work. Like, no, there has to be no expectation of pay, and you're just doing it to volunteer others. That's okay too. Okay, but certain things you should not do if you do not have work authorization specifically for those activities. And those include contracts like consulting work where somebody would like to pay you as a freelancer to, you know, consult with them at your hourly rate to do some side gig in addition to your business, just your job at a business, for your H-1B. Like, don't do that. Don't be a freelancer on like Upwork or Uber or any other platform, if you don't have work authorization. And even influencer work, if you are, if you have like a TikTok following or something, um, you might have opportunities for sponsors to pay you to promote certain products, but even that could be considered work. So be very cautious about engaging in any of these activities and definitely get the advice of an immigration lawyer before engaging in any of these. There are ways to set up visas before you have a green card through extraordinary ability to allow yourself legally to do what otherwise would be an unauthorized work activity. So that leads us to O-1 visas, what they are, who qualifies, and novel ways for how to use them. So, what are the basics? Well, there are several types of O visas, but for our purposes, the primary ones that matter are the O-1A visa for extraordinary ability and the O-1B visa for exceptional ability in the arts. And so it doesn't matter what your background is to qualify for one of these compared to the future job you want to have. So if you want to be the CEO of a startup and you've had a UX UI design career in product in the past, and that's where all of your accomplishments are, we could theoretically get you an O-1B artist visa to be the CEO of your future startup. We don't only get artists. If you get an O-1B, you don't have to be an artist, for example. So we'll just pick whatever category your evidence is strongest in, essentially. Now, the EB-1A green card is awesome because you can self-petition, and the EB2 NIW, which I'll mention briefly, which is also the fastest way to get a priority date if you're not already EB-1A qualified. But the O visas do not allow for self-petitioning. You do have to either be petitioned for by an employer who's offering you a job for the 3-year period, or by an agent who is responsible for your itinerary of services of essentially like gig or consulting or freelance work, or even jobs, for that same 3-year period. So if you want to be able to have those multiple streams of income and legally get, contracts for your services and do freelance work and be an influencer and get sponsorships, or even in the startup world, if you want to get advisory shares for advising other people's startups and exchanging your services for the equity, or if you just like need to pay for your rent and your ramen and so you need to be a consultant, those things would typically not be allowed on like F1 or an H-1B, but we've successfully, for many founders and other professionals, used the O-1 agent concept to allow for an itinerary of services in the fields of technology and engineering, for example. So in general, the way these categories work, I'll contrast it to an H-1B. An H-1B is very simple. It's like a 3-legged stool. You need all 3 for the stool so you don't fall over, right? So you got to have a valid company that's offering you a qualifying role, and you need to meet the education and experience requirements. And those are all very objective, and it's very straightforward. For an O-1, it's subjective, and what we're basically doing is we're putting together this whole portfolio of information about how wonderful you are, all of the things you've done, letters of recommendation. We write a really long, comprehensive support letter about how amazing you are and why you meet each of the legal criteria for how to qualify. And then if the officer believes that you have met the criteria according to a preponderance of the evidence, then their duty is to approve your visa petition from USCIS. With that, you go for your stamping interview if you want to be able to travel internationally. So the benefits of the O-1 are several. You can get a 3-year petition, and there's something that matters because we're in an election year here that's sort of a nuance, but I think it's important for you guys to know right now. So technically, the O-1 visa is for 3 years with unlimited 1-year extensions. And you could also apply for a series of brand new 3-year petitions. Under the Biden administration, it's been easy peasy for people to just get new 3-year petitions routinely and not have to extend in 1-year increments. Under the Trump administration, he instituted a policy called extreme vetting, where everything was met with intense scrutiny, just as if it were a new 1-year, a new petition that had never been filed before. So we found ourselves in a position back then where our clients preferred to take the less risky route of filing for 1-year extensions beyond the initial 3 years instead of attempting to get new 3-year petitions. So depending on how the events of this year unfold, we may find ourselves in a similar situation to that. So just be aware that if you want to get an O-1, I don't know in 3 years from now if you should get a 1-year extension or basically a 3-year subsequent new petition. But you can renew it unlimited in your lifetime, which is nice. Okay, now there's another concept that matters for folks, which is there's a difference between what I showed here, the 3-year or 1-year USCIS approval petition, compared to the actual visa that is this, people refer to this colloquially as a visa stamp when they go for their visa stamping interviews. It's a consular process, non-immigrant visa interview, and this is a visa foil placed into your passport. So the visa foils placed in the passport allow you to prove to the airplanes that you're allowed to get on the flight, and they show people at the airport the status that you should have when you enter. But these visas are typically, their duration is determined by reciprocity between the United States and your country of citizenship. So different people from different countries get O-1 visas valid in their passports for different time durations. So if you're from most European countries or India, you're usually going to get a multiple entry 5-year visa. If you are a citizen of China, you will get a single entry 3-month visa. So this is somewhat frustrating for some of my Chinese startup founder clients who would like to be able to go back and visit their family every year, because even if they have a 3-year petition approved by USCIS, every time they go home, essentially, they are going to need to go to another visa stamping interview and get a new visa to come back to the United States. So if you're from China and you want to get an O-1, most of my clients end up minimizing international travel until they eventually get a green card through the EB-1A category to just keep their life simple. And then another thing to keep in mind is with any consular interview, we don't know if you're going to be subject to administrative processing. This can apply to people who have traveled to Iran in the past, or there's a variety of reasons, and the consulates, we kind of don't know what they're doing. There could be background checks. So, but that's just like any visa stamping interview. there could be delays. So keep that in mind anytime you travel internationally. And if I had to predict the biggest change in business immigration that would initially come from a switch of the presidential party from Democrat to Republican, the most likely immediate effect for this audience is State Department officers who are currently on contract to reduce the backlog might end their contracts, and visa stamping might slow down because of that, because they'll have less capacity to renew visas at consulates. Now, if the Biden administration can pull it off, they had a pilot visa stamping program for H-1Bs this spring. Nobody knows how it went. They have not released data yet. Their goal was to formalize a stateside mail-in visa stamping program for H-1B, L-1, and O-1 visas. I don't know if they can pull that off by January 20th. If they do, it would be wonderful, because then you would just simply be able to mail in your passport, get the O-1 visa in it, and have it, mailed back to you or FedExed or whatever. So that would be lovely. That would make your lives a lot easier. Okay, now we've also talked about how with an O-1, you can have an agent. So this is usually a discussion that I figure out one-on-one with somebody. Do you want to use an agent? What sort of stuff do you want to work on in the US? Some founders are like, oh yeah, I need to be able to do a lot of things. And some are like, God, no, I have to be 200% on my startup. And that is the only thing I will ever do. And I have blinders, and don't even tempt me with other stuff. So it's a really personal decision. But if you need to work and have multiple streams of income, it is doable with an O-1. Some of the types of things that our clients like to do is being an employee at a company, plus advisory work, consulting work, maybe have 2 part-time jobs instead of 1 full-time job. You can kind of mix and match in different ways. And we also, it's one of my goals to craft these in such a way to minimize future amendments and allow people to be able to change jobs within their field during their O-1 approval period. So that's been very helpful and successful for our clients as well. And one of the benefits of having an O-1 with an agent is that you can take on more work that could set you up for an EB-1A down the road, because you can do more stuff that you could get paid for that helps you advance as a thought leader and leader in your field. So that can be advantageous as well. Okay, now what are the actual requirements? Well, there are 8 categories for O-1A that I have interpreted here for a startup founder audience. But as you can also see, you really can mix and match them depending on what your job is, what your industry is. People have really different types of jobs who can qualify for an O-1. So like a TikTok star and a, garage inventor might both get O-1s, but how they're going to do that is very different. So if your friend got an O-1 and you're intimidated because you didn't do what they did, well, it's definitely worth a look at what you actually did, because maybe you can qualify for other reasons. And if your friend or your colleague at work who's less accomplished than you got an O-1, then great, you're probably likely qualified as well. Once I had a client recently who was like, I signed like 30 letters of recommendation for other people's O-1s for my direct reports, and they all got it. But do you think I would qualify? And I'm like, yes, I think you would. So not being too scared and humble, and being at least willing to reach out and do an assessment, it's very valuable because it can help guide you on your path. So, okay, what are these categories? There's 8. In a nutshell, have you won prizes and awards? Are you a member of organizations that are hard to get into? Did people write about you in major media or in your industry? Did you judge who is an expert in your field? Did you create stuff that changes the way that people outside of your organization do things in your industry? Did you write stuff that had general circulation or that people who are experts in your industry read? Are you a leader in some important organization? And did you make a lot of money somewhere based on your salary based on the local geography and what people would typically make in that area. So there's so many types of evidence that can qualify. We just updated our O-1 checklist. It is 15 single-spaced pages. So this is only a snapshot, but we provide that to our clients so they can help think of all the different types of evidence that they've accomplished in their lives and give that to us. But if you're a scientific researcher who's written 15 papers and you have 200 citations and you've peer reviewed a bunch of papers and you like have posters at conferences, you're gonna have a very different O-1 than a startup founder that maybe raised 200K from like an angel investor or two, and you have some tech media articles about your company, and you've joined some founder organizations, and you've judged some pitch competitions, and maybe there's maybe you've been raising on safe notes and there's a valuation cap. And so what does that mean for your equity valuation? So lots and lots of ways to do this. And both of those people are going to be completely different from the, cloud engineer VP at a FANG that's been leading a team of, I don't know, 20 or 50 people. And, if your thing crashes, like a billion people suddenly can't use their phones or something. So we can help across a wide variety of industries. And one of the things that's been very useful to us to make stronger cases for our clients is in October, President Biden released his executive order on artificial intelligence. And so that definitely elevates anybody working in AI/ML. However, it also helps anybody in any critical and emerging technology. It is not related it is not limited only to artificial intelligence. So we're helping people in like wireless communication and 5G. We're helping people in life sciences and drug discovery. There are a lot of fields utilizing emerging technologies that are of the utmost importance to the United States at the federal level that have been recognized, and that helps us make a much stronger case than we were previously able to, because we have that formal recognition of why what you're doing is good for America. And although an O-1A is not an EB2 national interest waiver petition, we absolutely still use those arguments about how your extraordinary ability will help the United States in the future. Okay, so we went through that. Okay, so the visa bulletin also matters for this whole thing. Once you have an O-1, not even once you have an O-1, I would say one of the first orders of business of organizing your immigration future is making a plan for when you're going to petition and get your I-140 approved for a green card. Sometimes I have people about to graduate with a master's degree and they have 3 years of OPT and STEM OPT ahead of them and they want to be a founder. Sometimes we don't do an O-1 right away. We might get them an EB2 NIW approved first, and then the goal is for them to qualify for an O-1 before the end of their regular OPT, so we don't have to bother with the compliance requirements of the STEM OPT status. And they're starting their wait in line, and then they're going to get that. So they're basically getting regular OPT, EB2 NIW self-petition, change of status from regular OPT to O-1A, and then upgrade their green card by filing a subsequent EB-1A petition. Suddenly they can use their prior approval in the EB2 NIW category to have that priority date. But once they have the O-1 approved, they get deference on a subsequent EB-1A, and then they get to jump to the front of the line for EB-1A. So that, especially getting a head start on your I-140, matters most if you were born in India. If you were born, let's say, in Germany, and you're looking at starting an EB-1A now, which you might not totally be qualified for yet, versus an EB-2 NIW, the EB-2 NIW might add an extra 12 to 18 months of wait time to your overall green card process. So instead of like a year and a half, it might take 3 years. So it's a different calculus based on what country you and your spouse were born in. But this is one of the latest visa bulletins. So if you look at the visa bulletin from the State Department, there's family-based immigration, and there's two charts for um, final action dates and dates for filing. And USCIS is always finicky each month about which category they're going to look at. There might be retrogression this summer, but this just gives you a basic idea. This is what this is what USCIS has been following. If you have any priority date for EB1A and you are not born in India or China, you get to file your adjustment of status right away, the I-485 part of the green card process. If you were born in India or China and your priority date was before one of these dates in 2022, you're at the front of the line. You can use a really old priority date from a former employer, and then you're able to file your adjustment of status. If you're looking at the EB2 NIW category, and let's say you're born in Germany in that example, you would have had to file your first I-140 before March of 2023, and then you'd be at the front of the line now. For your I-485, China might take a couple years. India, it's really hard to say. It's not like a 1-for-1. So the fact that these people have been waiting for 12 years already for their adjustment of status, you don't necessarily know how many more years it will take to get to the front of the line. So there's the final action dates, which USCIS uses, and then the State Department uses another system called dates for filing, which is if you're out of the United States when you can file your immigrant visa application. But if you do it at a consulate like this, you don't get a work permit or travel permission, and you're waiting outside essentially for your green card unless you have another visa. Okay, so that leads us into our discussion of green cards and beyond, and what are the qualifications for green cards. And this is really important to my clients who have like worked in big tech, maybe for 10 or 15 or 20 years. They're still on an H-1B. Maybe they got their master's or even undergrads as well in the United States, like around 2010, and they're still working on this. So this really, really matters for a lot of people. Okay, so I kind of alluded to this at the beginning, but there's lots of paths up the mountain. If we're focusing on the side of the mountain with the employment-based pathways, there's 5 general categories. You'll be most familiar with EB2 and EB3 with PERM, which is what most employers typically sponsor. The categories you can self-petition are EB1A for extraordinary ability, which is the absolute fastest path to a green card, as we saw on those visa bulletin charts, as well as the EB2 national interest waiver pathway, which you can also self-petition. It's not as fast, but it's the easiest way. It's easier. I would say it's easier than an O-1. Not every lawyer thinks that, but I think in order of like hardness to get of how experienced you are, EB1A is the hardest, O-1A is the middle, EB2 NIW is the easiest. So for everybody on this webinar looking at self-petitioning a green card, the EB1A and the EB2 NIW are your 2 choices. So usually it's like, do I qualify for an extraordinary ability green card right now? If yes, proceed immediately. If no, think about maybe getting that initial priority date with EB2 NIW or waiting and improving my qualifications for EB1A to be able to file that. Oh, I did see 2 questions come in, and I do want to note that we've got about 15 more minutes. So for any more questions, I think now would be the time to start adding them so that I can calibrate the rest of our time appropriately and try to answer as many questions as possible. I did get one question from before, is pitching considered work? I don't think so. I don't think so. And I could explain that more, but you're just asking for money, but nobody's paying you to pitch. And if somebody is interested in giving you money, you will solve your immigration to be able to allow for it. So I would say no, pitching is not considered work. People do it all the time in B1 visitor status or F1 or H1B. It's okay. And then the second question I saw would be, what can be the options for PhD in pharmacy candidates? So certainly the O-1 and trying to get that priority date as quickly as possible, maybe through an EB2 NIW, but maybe you're already EB1A qualified. So we'll talk about that as well. So the green card process, and I kind of alluded to this, but it's usually 3 steps. But we're going to skip step 1. So if a company sponsors you, they have to go through perm usually for EB2 and EB3. And if you're going to sponsor yourself, you get to start at step 2, the I-140 petition. We already talked about how you would choose the EB1A or the EB2 NIW category. And then whenever your priority date is current, you are able to file step 3 if you're in the United States maintaining valid status. And step 3 is the I-485 adjustment of status process. Can take anywhere from 6 to 18 months. I've seen it get approved last year for a couple clients who had extraordinary ability in artificial intelligence in as little as 3 or 4 months. They got their I-485s approved before they even got their advanced parole. So that was wonderful. The advanced parole allows you to travel. The work permit allows you to work. Basically, once you file the I-485, you're stuck in the United States until it's approved, unless you have an H-1B or an L-1. And if Trump is the president, I would probably recommend not traveling, even if you have an H or an L valid visa, until you get your advanced parole. Once you have the work permit, like let's say you're on H-1B, but you also get your I-485 work permit, I would recommend in this political climate maintaining your H-1B for as long as possible. And you can have that work permit on the side. And if you want to do it, use it to do any outside work. You're welcome to that type of work permit. You can do anything you want. It doesn't have to be in your field. It could be anything. Great. Oh, I see the questions coming in. Okay, wonderful. Thank you so much. Okay, I'll try to get to as many of these as possible. Thank you, everybody. And some of these are already in my deck. So this is great. Okay. So EB1A, this is the fastest. If you were born in India or China, you probably eventually want to qualify for an EB1A. It is like the O-1 for extraordinary ability. It has 10 categories instead of 8 categories. It is the fastest. It optimizes for speed. Premium processing in this category means that the government, if you pay them an extra $2,800, will make a decision in 15 days. The adjustment of status can take up to 18 months. So it is not instant, but we can see it getting done for people not born in India and China, or people born in India and China who have an old priority date. You could likely accomplish this whole thing within 2 years, or maybe much less if you're lucky. And the EB2 NIW is different. It can be a stepping stone to an EB1A, or it can be an independent pathway in and of itself. It just depends on the timing. But the purpose of this is to optimize for the national interest of the United States, of why you in particular are going to help this country. As I mentioned, it's easier than an O-1A. You need to either have a master's degree or exceptional ability, and exceptional ability is easier than extraordinary ability. And it could be like a college degree, maybe 10 years of experience, maybe making a lot of money. It's a lot easier than an O-1. They do offer premium processing, but it's different. They'll make a decision in 45 days instead of 15 days. And what I really love about it, if you were born in India or China and no employer has completed an I-140 for you yet, this is a potential method to obtain a priority date so that you're at least eligible for those H-1B extensions, the H-4 EAD for your spouse, and you have a priority date and you're moving ahead in line, and then you can always upgrade to an EB1A later when you're qualified. Had a really compelling victory a few weeks ago for somebody who decided to file an EB1A with us. He's been a software engineer at a company for the last 20 years and has a special needs child. And that child would not be able to probably go to college in the US and get their own F1 or H1B. And so as that child's a teenager, it was really critical for them to be able to get the EB1A pathway activated so they could file their I-485s right away before their child turns 21 and ages out. And so that case just got approved. Not for anybody who's like well-known outside of their industry, but it got approved with no RFE immediately. So that was a really, really heartwarming and compelling, situation to be able to help in. Okay. Now a little bit more about what EB2 requires because it's different from from extraordinary ability. So once you prove that you have a master's degree or you have exceptional ability, then we go through this case called Danisar, which set the new legal standard like 8 years ago or something. And basically they want to know what you're doing is good, what you're doing is important for America. You in particular are good at doing this, and we shouldn't make you get a job offer or go through perm in order for you to self-petition. So those are some of the legal arguments that we make for you. So we have a lot of options to help you. So I'll go through this briefly, and then I'll focus on answering questions for the remaining time. So as you are thinking about embarking on one of these processes, it's important to keep a lot of factors in mind. Um, Money is one of them, but I would say more important might be your time, using your time wisely, focusing on getting the right evidence. If you need more evidence, assessing your qualifications early, being prepared for legal fees. We charge flat fees, typically on the magnitude of $10,000 to $15,000, depending on what the thing is that you need to prepare and file the petition. You just want to be prepared for all of that in advance. But for many of my clients, the biggest thing to prepare for is not the money, but it's the time and the imposter syndrome and the procrastination. So we have a service level agreement with deadlines where we try to keep you accountable to giving us all of your evidence in 6 weeks for regular processing and 3 weeks for expedite. I like to keep things moving forward expeditiously, but sometimes people just to have an accountability partner or friend who believes in you, who encourages you to actually give us all of your evidence on time so that we can support you. Sometimes people don't, and then we can't do anything to help them. So better to be engaged and proactive as you go through one of these processes. I do have a online class called Alorn Academy Extraordinary Ability Prep. It's 15 video modules available asynchronously, online, on demand. You can download it now. We have a promo code for you. Rebecca will be sharing those details in our email following up. And so that's been a hit. One of the things that past students really like is I actually took screenshots of like 100 requests for evidences that I've seen and gathered over the years and analyzed them for each category, explaining how that person could have had better evidence. And people say that's been really, really helpful for them as they think about what organizations to join, where to publish things, what type of competitions to judge, those sorts of things. But if you want an interactive opportunity for that, this is the QR code. This will also be in our follow-up. My next Alorn Academy Live is starting. Rebecca can put the start date in the chat window. I saw she just put the link to Teachable in there as well. This will be my third cohort this year. They're small groups. We meet every week for 1 hour for 8 weeks. And it's been a really great experience every time I've done it. The past participants have said it's very helpful. It's really helpful to know where they should focus their time and effort instead of like spinning their wheels, going in different directions, not being focused. And this legal framework is not necessarily intuitive. So I can just help you be like, oh, should you join that network security engineering society? I don't know. Let's pull up the website. Let's look at the requirements. Oh, is this one where it looks like experts are choosing you to join because they have vetted you and they believe you're an expert? Yeah, it does, because I can see on their website they have XYZ stuff. Great, apply for this organization. Looks good. Or don't waste your time, don't waste your money. That's never going to count. Don't use it. Those are the sorts of discussions we have. People have said that's very valuable. Oh, and thank you, Rebecca. The start date for the next Alorn Academy Live is July 31st. I believe it's going to be Wednesdays, 5 p.m. Pacific time for 1 hour for 8 weeks in a row. We also offer Legal Launch. This would be appropriate for you if you feel that you likely have enough evidence for an O-1A, EB1A, or EB2 NIW, but you're just not sure and you don't want to go through like a whole 8-week thing, but you just want like a checklist of if you have any more remaining items to complete or if you're already qualified, or maybe, yeah, you can just start now. So this is our 4-week assessment program. We give you our checklist, you upload our evidence, your evidence. We do our 3-stage internal review, and that culminates in an attorney meeting with what you can qualify for, your best strategy, when to start, if anything else is needed, and we credit the legal fee of $2,500 to your case if you start within 6 months. You can also just contact us for consultation. We usually charge for these, so be prepared for that. But we do have availability. 5 attorneys currently in the team, meeting with everybody. We'll ask you a simple questionnaire where you check boxes about your background, and that leads us to have a deeper conversation with you. And we can also recommend in that consultation if you should immediately start your O-1A or EB-1A, or if you should do the class or join the mastermind or do legal launch for the assessment. So lots of opportunities there. Okay, so I'm going to use the remaining time, 2 minutes, to try to get through as many questions as I can. You can also download my book from Amazon. It's also on audio. I recorded it, the audio book, so that's my voice. It's not AI. That was fun. And let me see how many questions I can answer. Lightning round. From your experience, how long does it take to get from the O-1A to the EB1A or the EB2 NIW if you're from the EU? You can probably get an O-1A within 6 months. Then we could start the green card right away, and you could probably have a green card in 2 to 3 years. And it would be faster with EB1A rather than EB2 NIW, but probably within 3 years in either case, you can have a green card. Do the few benefits of the O-1 overlap with a part-time H-1B? If yes, no, what are the benefits of the O-1 over the part-time H-1B? You can have 2 concurrent H-1Bs for part-time work at 2 different companies, but then you have to convince 2 companies to hire you, pay all the filing fees, and do an H-1B for you. With an O-1, you can have more than 2 companies. There isn't a set of additional H-1B filing fees. The company doesn't need to do it. Your agent can. It's more flexible. You can add and remove projects. So those are some of the benefits. What will be the duration of the process and how much will it cost? As I mentioned, it's typically 6 to 12 weeks to the time of filing. And it's typically $10,000 to $15,000, but it depends on other details. Do we help with the publication for the EB1A? No, I don't feel comfortable doing that. I don't have a publicity PR firm that I feel very strongly about recommending. I've been vetting at least 20 of them this year. I can't, in a compelling way, say that one has better services than another. I would just say never let them backdate any articles for you, because that could be construed as fraud or misrepresentation. What abilities apply to obtain the EB3? You need a company sponsoring you for a job, and you typically need a bachelor's degree. You go through the PERM process. The options, which are for people from India, all of them. Just some are faster than others. And our last question, does a part-time H-1B... Oh, that was a repeat. Okay, I think we covered everything. We're going to close there. You're going to be getting a follow-up email with a recording and all of our resources. I would love to have you join me in the class starting July 31st, but feel free to reach out to us anytime. We are ready to help and excited to support you in your journey. So thank you so much for listening, and have a wonderful rest of your day. Bye.